Kristi Noem is out. Mark Mullins is in. What does this mean for you? A leadership change at the Department of Homeland Security. What will this mean for you if you are a naturalized citizen, if you are a green card holder, or if you are currently on a visa? So what I definitely want to share with you today are the potential changes that will come under the new Secretary of the Department of Homeland Security, along with some practical solutions on how you can move forward. I have personally gone through the undocumented experience. I have navigated the entire immigration system myself, and I am also a practicing immigration attorney today. My purpose is to make sure that you stay fully informed about the latest and most current immigration updates, and not just the information itself, but how you can strategize, prepare, and plan for what lies ahead. So let us dive right into it today. Under Kristi Noem, we all know that it felt like there was a period of significant disorder, right? Some people might say it represented the most aggressive immigration enforcement ever witnessed. Some people might say they were relieved and felt that there was finally some real level of enforcement being applied. Whichever side of that debate you fall on, it was intense. It was the most aggressive immigration enforcement that we have ever seen in recent history. But what stood out to me the most is that under her leadership, approximately 170 United States citizens were actually taken into ICE custody. And there were actually 8 to 10 United States citizens who were actually removed from the country. And as many people are aware, there were 2 United States citizens who lost their lives during enforcement operations connected to Minnesota. So what led to this? Was it a direct result of her leadership decisions, or was it a matter of insufficient planning and insufficient training? We may never fully know the answer, but the one thing that remains certain is that she is no longer in that position and Mullins is now stepping in. With Mullins now in the role, and based on his background and professional history, there are 3 key things that you can expect under the new DHS Secretary. The first thing you can expect is a complete restructuring of how ICE carries out its enforcement operations. What does that mean exactly? It means that they are going to rethink and redesign their approach. This means there could be a more targeted and precise strategy, or there could be increased operations, but they will be more organized, more detailed, and more carefully planned. So it does not necessarily mean there will be less ICE enforcement activity. It could actually mean there will be significantly more enforcement, or it may simply be more strategic and focused. There might not be a dramatic, visible change overall, but the DHS Secretary must remain aligned with what the President has outlined as the primary goal, which is to have the estimated 11 million undocumented individuals leave the country. However, what they will take into consideration is the public reaction and backlash resulting from United States citizens being detained, United States citizens being deported, and even documented individuals, people with valid visas, being detained and living in a constant state of fear. These are real concerns that the new administration may choose to address directly, but we will likely still see an increased number of more targeted ICE operations, more individuals being stopped and questioned, and overall heightened enforcement activity across the board. There is not a great deal that any of us can do to prevent that, but I definitely anticipate there is going to be some form of internal restructuring, and they may begin paying closer attention to what both sides of the political conversation are expressing. Number 2, there will be broader and more expansive DHS priorities going forward. What does that mean exactly? Typically, the Department of Homeland Security prioritizes the safety and security of the nation and the protection of the border. So we may see a shift in funding directed toward cybersecurity and a shift in resources toward domestic relief efforts. Because as you may recall, there was a temporary pause placed on FEMA assistance for certain regions that were impacted by hurricane damage. We may also see significantly greater enforcement activity at the border and increased security measures placed along the border, because those responsibilities fall directly within the traditional scope of DHS operations. So what does all of that mean for you? That brings me to point 3. It means that there may be a meaningful shift in funding, a redirection of resources toward border security and toward those core DHS priorities. This shift in allocation could directly impact people who are currently applying for their green card, or people who are currently pursuing employment-based immigration pathways such as EB-1s, EB-2s, and NIWs. If there is a significant reallocation of where DHS funding is ultimately directed. So those are the 3 major changes that could affect you directly. In terms of enforcement becoming more targeted, in terms of increased scrutiny of online and social media presence, Because if they are investing more deeply in cybersecurity, they will be diving even further into digital footprints and anything connected to online activity and usage. Those are the three things you can expect to see under this new leadership at the Department of Homeland Security. But what can you do about it? I want to share a story involving one of my clients, which illustrates exactly the kinds of challenges that both naturalized citizens and United States citizens have been facing in recent times. A client came in, and he had some criminal charges on his record, specifically some felony charges that had placed him into ICE custody. When I reviewed the full case, I found that yes, he did have felony charges listed, but there were no actual convictions on record. He had already been set for deportation. When I examined how he had originally entered the country, I discovered that he had entered as a lawful permanent resident. He had a United States citizen mother. His United States citizen mother had petitioned for him, and he entered the country as a green card holder. So I said, we need to investigate exactly when that mother obtained her United States citizenship. Because if she became a United States citizen before my client turned 18 years old, then by law he would have automatically become a United States citizen himself at that point. So if a parent petitions for a child, the child enters the country as a green card holder, and you as that parent then become a United States citizen before that child reaches the age of 18, then by operation of law that child will automatically acquire United States citizenship. Once our firm looked thoroughly and carefully into that case, we were able to obtain a copy of the naturalization certificate. And what did we find? He had turned 18 after his mother had already become a United States citizen. So he is, in fact, a United States citizen who was being held in ICE custody. We contacted the family right away. The family was absolutely thrilled to hear this news, but they were also very anxious because they kept asking, how did DHS not catch this? How did ICE not catch this? So now it was entirely our responsibility, and we were working against the clock. Officials were reluctant to grant him bond even though he had not been convicted of the charges in question. But in immigration court, once you are charged with certain types of crimes, the immigration judge can examine the record of the proceedings and, whether you are formally convicted or not, they have the legal authority to determine that you can still be held and that you can still be considered deportable even without a final conviction on record. Those were the central issues we began fighting aggressively. We filed several motions on his behalf. After some time, we were unable to locate him within the system, and then we learned that he had already been transferred to Miami and was being prepared for deportation proceedings. We submitted all of the supporting documentation directly to ICE. They were unwilling to consider it. They were in the process of sending him back to his home country. I stated clearly that he is a United States citizen, and I presented the naturalization certificate of his mother along with the clear evidence that he was under 18 years of age when she became a citizen. Their response was, you need to file an N-600. And I told them directly that you need to keep him in the country so that we have the opportunity to properly complete and file the N-600. Long story short, the day before the scheduled deportation flight, we were able to file an emergency motion clearly stating that this is a United States citizen who is about to be wrongfully deported from his own country. And what I came to fully realize through that experience is that many ICE officers and many employees within DHS are simply not aware of certain laws. They are not familiar with certain legal procedures and processes, and this is precisely why some United States citizens have ended up being deported. This is why so many people are being detained when they have a perfectly valid legal right to remain in this country. They have valid documentation. They have a valid legal process actively in place. But due to a lack of proper education and a lack of accurate information among enforcement personnel, they are either detained for extended and unnecessary periods of time, or they are removed from the country entirely. I know some people are going to say, well, if he had not gotten into legal trouble in the first place, he would not have been in that situation. And perhaps that is a fair observation. But these are United States citizens. Life is complicated and unpredictable. People make mistakes and deeply regret them later. Keep in mind that he is now in his 30s. What happened occurred many years ago, and he was never convicted of those charges. I share that story to say that I genuinely hope that under this new secretary, there will be significantly improved and more comprehensive training for ICE officers, for DHS employees, and for everyone involved in immigration enforcement operations at every level. So what can you do right now under this new leadership and governance? Here are the 5 things that I strongly encourage you to take immediate action on, whether you have overstayed a visa, whether you are a green card holder, or whether you are a naturalized citizen, because it is becoming increasingly clear that moving forward, none of these statuses are entirely without vulnerability or risk. Number 1, get your taxes completely in order. This is critically important because unresolved tax issues can trigger a public charge determination or can lead to serious legal and immigration complications down the line. Make absolutely sure you address that promptly, because it is something that is being scrutinized more and more frequently when it comes to either petitioning for a family member or applying for United States citizenship. Number 2, avoid extended trips outside of the country. If you are a green card holder, you cannot remain outside of the United States for 6 months or longer without seriously jeopardizing your status, because this rule is now being actively enforced. Some people will point out that these rules have existed for a very long time, and they absolutely have. But enforcement is now operating at a significantly higher and more aggressive level. Old laws that have been on the books for many decades are now being actively applied and enforced. So yes, these rules may not be new or surprising, but they are being enforced far more strictly now than ever before. Avoid those long trips abroad, because if you remain outside the country as a green card holder for more than 6 months and you attempt to return without the proper documentation and justification, immigration officials have the authority to declare that you have voluntarily abandoned your lawful permanent resident status. Number 3, if your petition, whether it is your initial green card application or a removal of conditions based on a qualifying marriage, make absolutely sure that you strengthen and reinforce your supporting evidence thoroughly. You need to take this very seriously. You cannot simply present a tax return showing that you are married but filing as a single individual, or submit documents reflecting different residential addresses, or assume that a single joint bank account that you rarely use is now sufficient for any marriage-based immigration process. Even if the marriage-based process involves a child who is depending on its successful outcome, they're going to look back very carefully into the entire history of that marriage to confirm that it was genuine and entered into in good faith, and that you have the appropriate and thorough supporting documentation to back that up. Number 4, clean up your social media presence completely. That is a significant area of focus for DHS right now. They are going to substantially increase their cybersecurity and digital monitoring efforts. They are going to be actively and systematically reviewing social media accounts to determine whether you are engaged in anything unlawful, anything that conflicts with United States laws or policies, or anything that could be classified as hateful, discriminatory, or extremist in nature. Make absolutely sure your social media presence is thoroughly clean for any immigration process you are currently involved in. Even if you are simply applying for a travel visa, make sure your social media accounts are completely free of problematic content. It is truly the simplest and most straightforward step you can take right now, and I have personally witnessed people face very serious consequences because of their online activity, including United States citizens dealing with criminal proceedings and immigrants with pending applications who were negatively affected. And last but not least, before you submit your application for naturalization, make absolutely sure that you conduct a thorough and comprehensive audit of your complete immigration history and record. I am receiving far too many cases now involving individuals who decide to file for United States citizenship, only to have their entire immigration history re-examined from the very beginning. Officials are taking a full second look at the complete immigration record, and people are finding themselves confronted with old issues they genuinely believed had been long resolved, and in some cases having their citizenship application denied outright and being placed into removal proceedings because of events or circumstances that occurred many years earlier. So make sure that you complete a full and detailed audit of your entire immigration history before you actually submit your N-400 application. I truly hope this information is helpful to you. If you found this video valuable and informative, please like it, share it, and subscribe to US Visa and Green Card Info, and pass it along to someone who might benefit from hearing it.